I want to reject certain statements I see on the public record from certain journalists that Mr. Saddam Hussain, the Chief Education Officer of Guyana, was found guilty of contempt of court. That is not true. Today, Mr. Hussain was summoned to the court by Justice Anil to show cause why he should not be committed for contempt. I appear for Mr. Hussain, and after some exchange, I was able to make representation on behalf of Mr. Hussain. I made it clear to the judge that it is not the intention of the government of Guyana or any of its officers to disrespect the court system, the administration of justice, or to disobey any court orders. That the circular that Mr. Hussain issued came out of an engagement that I had with the Ministry of Education officials in relation to the case. At that engagement, it was reported that the teachers were being informed by the union, rather misinformed by the union, that deductions will not ever be made from their salaries, that the case is concluded, and that they can continue to work and there will be no penalty. To dispel that misinformation, I advised that the Ministry of Education continue to make a record of the absences of teachers and to inform or clarify that the order of the judge is temporary and that at the end of the day, when all of this is finished, teachers' salaries will be deducted for the period that they have not worked, because that is the law. No work, no pay. And I asked that that be sent out in a circular. Unfortunately, the circular was not shown to me prior to it being sent out. And when it was drawn to my attention, it was already sent out. I will concede that it was not expressed in the best language possible, and that it is capable of some unfortunate interpretation. And the judge recognized himself that it was capable of multiple interpretations, some of which are not good for the administration of justice. I agree that it is capable of more than one interpretation, and one of those interpretations or some of those interpretations can have an adverse impact on the administration of justice and even cast aspersions on the court itself. Mr. Hussain was invited by the judge to speak, to explain his position, and he did so very eloquently and very clearly. I believe that he was able to persuade the judge that whatever mistake was made was not intentional. He reiterated his and the ministry's intention never to disobey any order of court, and certainly it was not their intention to disobey the order of court in this instance. He acceded to the contention that the memorandum or the circular was not worded in the best possible language, and he offered to rescind it. The judge accepted the invitation that the offer that Mr. Hussain has made, and I believe the judge eventually was persuaded that there was no intention to bring the administration of justice into disrepute, or any intention was evinced to violate the order of court or any order of court. So that is what brought that proceedings to an end. So it's completely wrong and misleading for reporters who are present in court to now say to the public that Mr. Hussain was found guilty of contempt of court. There was no hearing. The contempt proceedings was not tried on its merits. There was an engagement between the judge, the Attorney General, and Mr. Hussain. And the judge, I believe, was satisfied that no contempt of court was committed and the matter died a natural death. There's a second point made by the court which I want to also clarify, lest it become the subject of discoloration and misinterpretation. The judge invited the parties, the union and the government of Guyana, to consider re-engaging or engaging. The judge, I suppose, exercising mediatory powers which the court has in any given case, said that he would like to see the parties talking, as the public good is not served by this continuous strike action. I indicated to the court that the government would like to see the teachers in the school. The judge also said that he wants to see the parties at a table talking. The judge wanted me to give a commitment that this will take place. I respectfully informed the judge that I act on behalf of a collective, and I'm only one member of that collective, and I need to get the collective's opinion and guidance before I commit them to any course of action. The judge even invited me to suggest a mediator. Again, I indicated to the court that the court is putting me in a rather invidious position of unilaterally determining on behalf of a collective who a possible mediator should be. Again, I invited the court to give me an opportunity to speak with the government of Guyana, which is the collective to which I'm referring, and report back to the court. Tomorrow, the case has been adjourned for tomorrow at 3 p.m. for me to make such a report. So I just thought that I'll put that on the public record personally, because I know, well, not I know, I fear that it will be the subject of misinformation again. So I thank you very much. There's another important point that I want to make. I concluded prematurely. And the point is that I inquired specifically from the court whether this intervening suggestion of a mediation is going to affect the dates and time frames already given by the court in relation to the substantive action. And I was assured that those time frames and that course of action already outlined by court orders remain intact, that this suggestion of a mediation is not going to affect the outcome. Why I want that to be clear? Because I want this matter to be concluded swiftly, and even more importantly, I want the issues of law to be clearly pronounced upon by the court, because the law needs to be clarified in this area. Thank you.